Shalom, my name is Michael Decker and I'm a lawyer within the law offices of Cohen Decker Pex and Brosh. Today I wanted to discuss a specific topic which is relevant but is not well known, and that is in regards to the birth of a child to an Israeli citizen that's a second generation abroad, meaning the birth of a child to an Israeli citizen that himself was not born in Israel. Section 4 to the law of citizenship basically distinguishes between children born to Israeli citizens in Israel and children born to Israeli citizens outside of Israel. And basically, in regards to children who are born to Israeli citizens outside of Israel, Section 4 stipulates various ways whereby the child of an Israeli citizen that's born abroad will obtain Israeli citizenship. Basically, if we are dealing with a first generation birth outside of Israel, meaning a child that's born to an Israeli that was born in Israel, the modus operandi of the Interior Ministry is to compare the situation of this child to the situation of a child born in Israel to Israeli citizens, and this child will automatically receive Israeli citizenship based on the merits that he was born to a parent that's an Israeli citizen. The parents will basically need to go to the Israeli embassy and register the child, and if and sometimes proof will be required, maybe even a paternity lawsuit. It will be submitted to prove a connection between a parent and a child. But once this connection is proven, then the child will automatically receive Israeli citizenship based on the merits that he has an Israeli parent. However, the policies of the Interior Ministry then distinguish between a first generation birth outside of Israel to a second generation birth outside of Israel. And when we are dealing with a child born to an Israeli citizen that he himself was born abroad, meaning a second generation birth, then the child doesn't receive citizenship based on the merits of him or her being born to an Israeli parent. In a situation like this, the child may receive citizenship in other ways. So the main way is through the law of return, and therefore, if this child is born to a parent that's Jewish, or if this child is a grandchild of a Jew, then this child should receive citizenship after the parents register him in the Israeli embassy, or if he didn't arrange it on time, then as he grows older, he can also arrange this at the Israeli embassy or come to Israel and obtain citizenship through the law of return. However, not all citizens of Israel are Jews or eligible to immigrate as descendants of Jews. Or they may be eligible, but they may be excluded from eligibility because of other reasons. So, for example, if a child born as a second generation abroad to a parent that was born abroad, if he did not arrange his status when he was young, and if he is eligible to immigrate but violated a crime, is a criminal abroad or has a criminal background, then the law of return won't apply on him, and this child won't be able to automatically get Israeli citizenship just because he was born to Israeli parents. Or fourth generation Jews are not eligible to immigrate. So if a child of a fourth generation Jew is born outside of Israel when this fourth generation Jew was not born in Israel, this child won't be eligible to immigrate, to get automatic citizenship. Or if a child born to a parent that was a Jew but changed his religion, for example, and he's a second generation birth abroad, then also this child won't be able to automatically get citizenship by birth through the law of return because he's not eligible to immigrate anymore, according to the law of return. In addition, Israel has non-Jews, Arabs, Druze, and other communities. So therefore, this specific policy of the Interior Ministry deals specifically with second generation births outside of Israel when the child is not eligible to immigrate according to the law of return. And the policy doesn't give any clear solution. It just says that the parents need to submit an application to the Minister of Interior. Therefore, it is our opinion that in a situation like this, it is very important to consult with a professional lawyer and to make sure that a very convincing application is submitted. And in this application, it's important to prove the connection between the Israeli parent and the child that's not a citizen, the connection to the land of Israel, the connection to family in Israel. And naturally, since we're dealing with a minor child, and an adult parent that's a custodian of a minor child that's a citizen, we believe that it definitely should and is possible to obtain citizenship to such a child born abroad as a second generation to an Israeli citizen. If this is your case, you can please feel free to contact us and we'll be happy to assist you in any way we can. Thank you very much.